implementation of this new act. I'm sure you'll have lots of questions. I think there's a lot of sort of things that are yet to be seen as to how it's going to work in practice, sort of based on experience from the system in England and the Children and Families Act. It's likely that, you know, there will be teething problems, and, you know, we can anticipate them as much as possible, but really these things will start to come out in the wash as we start to see the transition take place. So as Kate said, I'm a solicitor at Irwin Mitchell. I work in the public law and human rights team, and I specialise in education law. So I act for both Welsh and English clients. So in terms of what we'll cover today, I'm just going to start off with sort of I'm going to be brief, because I'm sure you know, a number of you are aware of the current system, have had some involvement in it, potentially, but to give you a bit of a background and overview of the education system in Wales, also a sort of brief introduction to how the system is currently, and then more importantly to focus on the Additional Learning Needs and Education Tribunal Wales Act and the new system that's coming into that has, you know, recently started to come into force. And if possible, if there's time, although there is a significant amount to get through, to take a couple of questions at the end, just to say on this as well, I think if I was to cover everything, this seminar would take probably a day. The code of practice for the new act it comes to over 380 pages, so there is a lot there, and what I've tried to do is sort of pick out the key information and signpost. So that's how I sort of hope to go through things today. So in terms of just moving on slides there, if in relation to education law in Wales, education is a devolved matter under the Government of Wales Act 2006, which means that the Welsh Government has responsibility for creating laws in relation to education in Wales as opposed to Westminster, and Wales continued to apply the Education Act 1996 after the Children and Families Act came in England in 2014. And obviously it's now, you know, 25 years old. It's the sort of impetus for the change is that it can be quite complicated, it can be quite convoluted. There are sort of different ways, there are different bodies with different responsibilities, and you know, it's intended now to sort of bring everything together, or that's at least the hope. And there is still other relevant legislation which I've just highlighted there. So in relation to transport, which I may touch upon but won't go into in too much detail today, there's the Learner Travel Wales measure 2008, which will continue to apply. There's also the Equality Act, which is relevant to discrimination, and I've just picked out the current Special Educational Needs Code of Practice for Wales there, and the Special Educational Needs Tribunal, as it currently is, must have regard to it and needs to give reasons if it seeks to depart from that guidance. So under the Education Act, so in terms of the definitions, as I say, I won't spend too much time on this, but it just gives you the context for the changes that are coming in. So special educational needs in section 312 of the Education Act, it means a child in the area of the local authority in Wales. They have special educational needs if they have a learning difficulty which calls for special educational provision to be made. And they have a learning difficulty if they have a significantly greater difficulty in learning than the majority of children of their age, or they have a disability which prevents or hinders them from making use of educational facilities of a kind that are usually provided for children of their age within schools within that local authority's area. And if they're under compulsory school age, it would be whether they meet that test if they were of that age. So this is focused on what facilities you know, are available within the local authority's area. So there's potential for differences between different local authority areas and the educational facilities that are available in those areas. And special educational provision. So when we're looking at whether they have a learning difficulty which calls for special educational provision to be made, that means in relation to a child who's 2 or over, provision which is additional to or otherwise different from the education provision generally made for children of their age in schools maintained by the local authority. For children under that age, it's educational provision of any kind whatsoever. So currently there's this three-tiered graduated system. So school action plus, school action for children who have these additional needs, where a class teacher or SENCO identifies a child with special educational needs, and they should provide these additional interventions within the classroom to that are additional to or different from those provided as part of the usual curriculum. And those strategies are then recorded in an individual education plan. School Action Plus is a step up from that, so a child continues to experience the difficulties despite that programme of support. They may request support from external agencies, and the SENCO will sort of work with those agencies and the teachers in consultation with parents to review the IEP and to produce a sort of revised IEP with that specialist input. And then if that child's still not making the progress expected, then you may look to a request for a statutory assessment and a statement of special educational needs, which I'll come on to. So when's a statement required currently? So it's if the local authority believes the child probably has special educational needs, and that it needs or probably needs to determine the special educational provision by making a statement. It will do that where it considers that the special educational provision necessary to meet the child's needs can't reasonably be provided within the resources normally available to maintain schools in that area. So that's where we are currently, and at the moment statements will cease automatically if a child leaves school at 16. If they stay in school, they can maintain until they're 19 or the end of that school year, but that's about to change, so I'll come on to that. Let me just check. Are you managing to keep up with me in terms of slides? Sorry, I've probably been...
No, that's fine.
Great. Sorry, I've just probably been going along without telling you where I am. No, brilliant. So yeah, in terms of the parental right of appeal to the Special Educational Needs Tribunal, if the local authority refuses to do a statutory assessment, if they refuse to issue a statement, parents can appeal contents of parts 2 to 4 of the statement, and they can also appeal a decision that the local authority takes to cease to maintain the statement. They've got 2 months to make that appeal, and that would be in the Special Educational Needs Tribunal for Wales, or CENTU as it's sometimes known. There is currently it's being renamed, but there is currently these 2 systems running in parallel. So what I'll come on to is there's actually 2 websites, one for CENTU as it was known, and one for the Educational Tribunal for Wales as it will be known going forwards. And so knowing where you are, in which system you fall into, will depend on which website you access if you are looking to appeal. And I'll put those links later on in the slides. So statements, just a broad overview of what they cover, so how they're set out. So the key sections are really the special educational needs in part 2, the special educational provision in part 3, placement in part 4, and then it goes on to non-educational needs and provision. It will change. The new individual development plans do look very different. They look they have parts and sections, and we shall see, but I'm hoping that it won't become too confusing, but from what I've seen so far, it feels like it may have the potential to, but I'll do my best to explain how it's supposed to work in practice. Okay, so moving on to the next slide then. So currently post-16 education is dealt with separately, as I said, so the duty to secure education and training for young people in post-16 education actually rests with the Welsh ministers instead of local authorities under the Learning and Skills Act. And that can create a bit of a lack, there can be a lack of a joined up approach then when young people are transitioning into post-16 education, particularly those with special educational needs. And Careers Wales can provide independent advice in relation to people with special educational needs on post-16 options, and potentially undertaking assessments of needs under Section 140 of the Learning Skills Act, and looking at specialist post-16 placements. But the idea of the new Act is that these young people will come under an individual development plan, which could potentially remain in place until they're 25. Okay, so now looking at the Additional Learning Needs and Education Tribunal Wales Act. So it was passed by Parliament in January 2018. So it's been a quite a long time coming. And the idea is that it will be a phased implementation from the 1st of September, just passed, over 3 years. So there'll be 2 systems effectively running in parallel until 2024. Now, as I said before, we know from the Children and Families Act that actually the best laid plans, don't always come to fruition. And actually, we saw it took quite a lot longer to get children transferred from statements to EHCPs in England. I suspect we may see something similar here, but unhelpfully, and I really hoped today that we would have the implementation guides, because they were promised in the mid-autumn term. And I emailed the Welsh Government, I think on Monday, to check where they were. And they told me that they are being published this week, but we don't have them yet. I checked this morning. So if I'd had that, I was hoping to go through and quickly digest everything and give you a bit of a brief summary. I don't have them. And so the position in relation to implementation remains somewhat unclear. My advice is to look out for those, and when they come out, those are hopefully going to be sort of your best bet in terms of knowing how and when your children will be transitioning to the new system. And I'm hoping that they'll be very sort of helpful, because they're going to have one specifically for parents. So watch this space. Hopefully they will come out. They may come out whilst we're having this training session, who knows. But that's where we are. As I said, the rationale for change is that the current system is not really fit for purpose anymore. It's bewildering, it's adversarial. Families feel like they have to battle at each and every stage, and I mean, I'm hopeful that this will change things. I do have some concerns which I will highlight, but in theory it is designed to sort of bring it all together under one plan, and for children who have special educational needs or additional learning needs. So in relation to the Act, the ALN code for Wales it was approved by the Senedd in March this year, came into force on the 1st of September. So I put the link there to that. That's probably a go-to document, really. It's as I said, it's extremely long, but it does sort of helpfully break it down into different sections depending on what age your child is, what type of school they attend, and then that's probably the best document for you to look at. The most recent statement we have from the Welsh Government, so that was from Jeremy Miles on the 14th of July this year. That said, the implementation of the ALN system for the first year will be sequenced. Children who are newly identified as having additional learning needs, so that's those without already identified special educational needs, so without School Action Plus, or are not awaiting or undergoing a special educational needs assessment already, will still move to the new ALN system from the 1st of September. However, for those children who attend a maintained school, including a pupil referral unit, and who already have that identified special educational need through School Action or School Action Plus, then the new system would apply from the 1st of January next year. And he said that he expects the sector to use that period to reflect on the guidance, begin preparing and engaging those who already have identified SEN in School Action or School Action Plus with their transition to new arrangement. So things should start to be happening in terms of preparing for that. The intentions that eventually they will take over from existing learning support plans, so statements, IEPs, and learning and skills plans will all become IDPs. But as I said, it sounds quite complicated. I think it will take longer than they think it will. And we just sort of need to watch this space for the implementation guides to see where we are. So in terms of 1st of September, it applies to all children newly identified as having ALN, and that's sort of in any setting. It doesn't include those children who have a statement or School Action or School Action Plus, or the equivalent Early Years Action or Early Years Action Plus. And if those children are already engaged with the statement process, if they started doing the SEN assessment process, then they're not considered to be new to the ALN system. I do think the position in relation to implementation is slightly unclear. I have looked, and the commencement orders, which are the orders that were due to bring in the provisions in relation to children with school action and school action plus, were revoked in August, and we haven't had a statement from the Welsh government since updating on that. So a further update is awaited. We need to see what these implementation guides say, and I'm sorry that can't be more helpful as to how this is going to work in terms of the transition immediately. What I can do is tell you how it's supposed to work in practice, and how what you should be looking for, and the steps that schools and further education institutions and local authorities should be taking, and I'll come on to this as well. So in terms of the code, as I said, that's your go-to document. It is a color-coded system. So it's got this must, which is the color codes are in the code. A must is a requirement in the legislation or code to do something. So that's an enforceable duty. Must not, again, prohibited in law for doing something. So if they do something that they're prohibited from doing, that's unlawful. May means that they can do it, but they don't have to. And should or should not means that they should be doing it. They should be following it unless they can demonstrate there's good reasons for not following it. And so usually that would be they would have to demonstrate those circumstances that justify that. Okay, so coming on to the definitions in the new Act. So the term special educational needs is replaced with the term additional learning needs. And Section 2 of the Act says that a child has ALN if he or she has a learning difficulty or disability, whether that arises from a medical condition or otherwise, which I think is important, which calls for additional learning provision. And the code summarises the test for ALN for children of compulsory school age as whether they have a learning difficulty, and that's a significantly greater difficulty in learning than the majority of others of the same age, or do they have a disability which prevents or hinders them from making use of facilities for education or training, which is generally provided for others of the same age in mainstream maintained schools or further education institutions. And if so, does that learning difficulty or disability call for additional learning provision? And in terms of the definition of additional learning provision, I'll come on to that. There is a helpful glossary in Chapter 1 of the Code of the ALN Code, and Chapter 20 contains guidance on identifying ALN and deciding upon ALP. So that's a good place to look. And the definition of additional learning provision. So ALP is educational or training provision additional to or different from that generally made for others of the same age in mainstream maintained schools in Wales, further education, mainstream further education institutions or nurseries in Wales. So that's the test, and that's helpful because you're comparing it across the whole of Wales. And if so, first of all, does the child have a learning difficulty or a disability which prevents or hinders them from making use of those facilities generally provided for others in mainstream maintained schools? And this calls for additional learning provision, i.e. They need that educational or training provision which is different from or over and above that generally made in mainstream maintained schools in Wales. Then they have ALN for the purposes of this Act. And if they have ALN, an IDP should be made for them. So in terms of identifying ALN, as I said, Chapter 20 of the code has some helpful information on this. I've just picked out some sort of key points. So evidence can come from various places. It can come from staff, other services involved with the child, parents or the young person. Where there's an identified disability, the evidence will relate to what that disability prevents or hinders the child from doing. Excuse me, in terms of making use of those facilities usually provided, and likely that will involve advice from specialists involved with that individual. Where the child doesn't have an identified disability, it's really likely to be observing and assessing their progress through things like screening assessments, questionnaires, personalised assessments, that sort of thing. Excuse me. Sorry, I've just got over a cold, so I'm losing my voice slightly. So, and the other thing to note is that slow progress and low attainment don't necessarily mean that they have ALN, and it doesn't automatically lead to a decision that they have ALN. But where that progress continues to be less than expected, and there's been sort of differentiated approaches that haven't addressed that attainment gap, that would usually indicate that the child may have ALN. And then there are these requirements to consider, and it's on local authorities, not schools, to consider seeking advice from an educational psychologist. And there are circumstances where they must seek an advice from an educational psychologist. And I'll come on to that as well. Okay, so the next slide. So this is just another helpful bit in terms of identifying ALN. It's about identifying the learners making less than expected progress, so progress significantly slower than that of their peers, which fails to match or better their previous rate of progress, which fails to close or widens the attainment gap between them and their peers despite the provision of support. So in terms of those are the definitions. In terms of other key changes, so as I said, school action plus, early years action plus, and statements will be replaced by an individual development plan. Everyone who meets that definition and has additional learning needs in Wales will get an IDP. That's the aim. And you can have an IDP up to the age of 25 unless a decision is taken to cease to maintain it, which is the same as the position with EHCPs in England. You'll be pleased to know that there is an enhanced focus on participation of the child, parent and young person. So any person exercising functions under this Act, so for the school, the governing body, the local authority, must have regard to the views, wishes and feelings of the child and the child's parent or young person, and the importance of the child and the child's parent or the young person participating as fully as possible in decisions. So that's helpful. There's this new ALN co-role for maintained mainstream schools and further education institutions, and they're responsible for coordinating provision of learners with ALN. And I'd come on to that on the next slide here. So this is addressed in Chapter 8 of the new code. All mainstream maintained schools and further education institutions in Wales must designate a personal person who will have responsibility for coordinating learners with ALN, and this is the ALN Co. I've just set out there some of the responsibilities of the ALN Co. It's a statutory role which effectively replaces the existing non-statutory SENCO role that exists in most maintained schools, and similar non-statutory roles in further education institutions. In terms of qualifications, they must be a school teacher or a further education teacher, and unless they were SENCO before January this year, because these statutory roles came in January this year. And every local authority must designate an early years ALN Co as well for children under compulsory school age who aren't attending maintained schools. So the next slide then. So in terms of routes to the IDP, I think this is where it can become quite complicated. And I've done my best to break it down for you. It is set out in the Act and in the code. As I say, the best thing to do is to check which section your child falls under in terms of what school they attend and whether they're compulsory school age or below, and then look at that section, because I can't cover off the circumstances for everyone because it does get quite complicated. But broadly, either the school, the further education institution or the local authority can prepare the IDP. So this is different to the situation in England, where it's the local authority's responsibility to prepare an EHCP. But it appears that the intention is, because this will cover all children with ALN, including those who would have previously fallen under school action plus, that actually the less complex plans will be able to be maintained by the schools. And then if the child needs sort of more complex provision or over and above what the school can be reasonably expected to provide, then the local authority will get involved. But the code does say that maintained schools have a key role to play in identifying ALN and delivering ALP. They're directly responsible for identifying and meeting the needs of the majority of their pupils with ALN. So that's the expectation. The local authority will get involved where it's brought to their attention or otherwise appears to them that a child may have ALN, or where they're asked to reconsider the school's decision, because there will effectively be a right to ask that the local authority steps in if you're unhappy with the decision taken by the school, and then the local authority's decision could be appealable to the tribunal. So it kind of adds in an additional step, and we'll see. I feel that there is potential for it to become quite complicated and for there to be disputes between schools, local authorities, and I'm interested to see how that plays out. Hopefully it won't, impact things on the ground, but I do have my concerns. So the first route to an IDP, on the next slide. So where it is brought to maintain school's attention or otherwise appears that a child may have ALN, so that's may, they must then make a decision, and that's must, if they do have ALN, unless there's already an IDP being maintained, the school has previously decided the issue, and there's been no material change. Child's dual registered at 2 schools, and the local authority is responsible for the child, in which case the local authority must make that decision, or they have an EHCP because a local authority in England maintains it for them. So when it's brought to their attention and it has to make that decision, the school must designate someone responsible for that decision. That may be the ALN code, but not necessarily. Record the date it was brought to its attention or appeared that the child may have ALN. Record a summary of how it was brought to their attention or appeared to them. Notify the child and parent that they're making that decision, and consider an initial meeting with the child and parent. This applies to maintained schools. Independent schools and independent specialist post-16 institutions are not required to have regard to the code and its requirements, as it will be the local authority responsibility to maintain the statement, the IDP for children at those schools. And the possibility that a child has ALN might be brought to the attention of the school by parent, child, family member, other professional. It doesn't really matter. Once the school become aware that a child may have ALN, they must then make that decision. And in its most basic form, they're then responsible for assessing and preparing and maintaining the IDP, although there are some exceptions, which I'll come on to. So if a decision is taken by the school that the child doesn't have ALN, it must notify the child and their parent within 35 school days of it being brought to their attention or appearing to them that the child may have ALN. That feels like quite a short time frame to me, because the local authority has a lot longer, and I think that is supposed to reflect the fact that it's because this also applies if they are going to make an IDP, they still only have 35 school days. I'll come on to that on the next slide, but I think that's to reflect that it's really going to be sort of the less complex cases where the school is preparing and maintaining the IDP, and so it's really just deciding what support's required and getting that put into a plan. It may just be that for children with school action or school action plus the same provision, it's just formalized into a plan. So in terms of the next slide, if the school decides a child has ALN, it must prepare an IDP, unless it would not be reasonable for the school to secure the ALP the child requires. The school can't adequately determine the extent or nature of the child's additional learning needs, or it can't adequately determine the additional learning provision. So as I say, I think this is where in the more complex cases, it may then be for the local authority to prepare the IDP instead of the school, in which case the school will then refer to the local authority, which it should usually do within 20 school days of realizing that the child may have ALN. And there are other circumstances where if the child's under the English system, the school doesn't need to prepare an IDP. So if the school decides that the child does have ALN, they must make that decision, prepare the IDP, and give a copy of it promptly, and in any event before the end of 35 school days from it being brought to their attention or appearing to the school that the child may have ALN. And there is this exception, which is unless it's impractical to do so due to circumstances beyond its control. This will be interesting to see what comes of this, because it's not sort of entirely clear. There is some guidance in the Act about when it may be used, but it doesn't appear to be sort of a sorry, I say that in the Act, I mean in the code, but it doesn't appear to be exhaustive. So I don't want to see sort of local authorities using it, this exception, regularly, but we'll see what happens. So what the code says is that the school should give the child and the child's parent an opportunity to comment on the draft IDP and encourage them to raise concerns ASAP, and then should act upon them appropriately. Now, this is a should, it's not a must. That does cause me some concern. We'll see how that plays out, because you know, it's not sort of a statutory requirement to give that that opportunity, and I hope that that's not diluting parents' rights. Will ultimately still have the right to appeal to the tribunal, but at this stage, you know, it'll be interesting to see how that works in terms of local authorities giving that opportunity to comment on the IDP. The school must give contact details for the school, information about how to access local authorities, arrangements for accessing advice and information about ALN, details of dispute resolution and advocacy arrangements, and information about the right to request that the local authority reconsiders the plan and takes over responsibility for maintaining it. And that's an important one. That's your right to request that as a parent. And where a maintained school has prepared an IDP, unless that responsibility is transferred to the local authority, as we've discussed, it must maintain it. So it must secure the additional learning provision within it, except any which is provided by an NHS body, in which case the NHS body must secure it. And if the IDP specifies that a particular kind of ALP should be provided in Welsh, then the school or NHS body, where applicable, must take all reasonable steps to secure that it is provided in Welsh. Okay. So in relation to referrals from the maintained school to the local authorities, there are two circumstances where they must refer to the local authority. That's where a child's dual registered at two schools or is looked after by the local authority. But they can also refer in other circumstances. They just don't have to. If a child or child's parents request that the local authority reconsiders the decision made by a maintained school, then the local authority must then decide whether or not that child has ALN. As I say, that is your right to request that. If you're not happy with the decision by the school. So the local authority must then notify the child and parent of the decision and reasons within 7 weeks of receiving the request for reconsideration. Okay, moving on to the next slide then. So the second route is through the local authority. So where it's brought to a local authority's attention or otherwise appears to the local authority that a child may have ALN, the local authority has to determine if the child has ALN, unless there's been no material change. Again, there's these steps that they have to take. So designate someone responsible for making that decision, recording the summary of how it's brought to their attention, notifying that it's making that decision, and considering offering the initial meeting. And when deciding whether the child has ALN, the local authority must consider whether to seek advice from an educational psychologist. So at the very least, they must consider it. But if they consider it's necessary to determine the extent or nature of the ALN or the ALP called for by the ALN, then they must seek advice from an educational psychologist. I think that's going to be sort of a helpful part of the code to draw the local authority's attention to effectively. If you feel that you know, that educational psychology input is necessary in order to determine the ALN or the ALP. So it could be anyone, again, who brings it to the local authority's attention. It could be a health board in Wales, could be a childcare provider. Parents might raise concerns through a non-maintained setting directly with the local authority. It doesn't really matter again. But if it is a direct approach by a child or parent or other family member, and they're in a the child's in a maintained school, then it might consider that the matter's better decided by the school and bring it to the school attention instead, thereby triggering the school's duty to consider whether the child has ALN. So this is why I say it can become convoluted. I feel like there is potential for passing the buck which does concern me slightly. We shall see. I mean, I think the key point to bear in mind is that you have that right to request that the local authority reconsider. I am concerned it will add in delay. The Act tries to mitigate against that, but I do think it will add some additional delay. If the local authority decides a child doesn't have ALN, it must notify the child and parent of the decision with reasons promptly, and in any event within 7 weeks if they're reconsidering the school's decision, as we just discussed, but in all other cases within 12 weeks, unless it's impractical to do so due to circumstances beyond its control. And as well as giving that decision and reasons, it must give contact details to the local authority, again the information about their advice services, details of advocacy and resolution of disagreement arrangements, and importantly, again, information about the right to appeal to the tribunal. And so it could potentially be a long-winded process. So the school could decide the child doesn't have ALN, parents are asked to reconsider, parents ask the local authority to reconsider, the local authority then considers if the child has ALN, if so, whether it should provide ALP or whether the school could provide the ALP. If the school should provide it, then the local authority can direct the school to maintain the IDP, so it becomes very circular. And I feel that there is potential for conflict between schools and local authorities, which will be interesting, especially when maintained schools likely have the same legal advisors. So we'll see how that plays out. And even where a local authority decides a child doesn't have ALM, the Act says that they should outline what action the school and local authority will take to ensure that needs are met nonetheless. If, on the other hand, the local authority decides the child does have ALM, they must prepare an IDP and maintain it, or alternatively direct the school to prepare and maintain the IDP, as we've just discussed. And again, this should give the child and child's parent an opportunity to comment on the draft and encourage them to raise concerns ASAP. Have the same concerns around that. So the local authority must make the decision on ALN, prepare an IDP, and give a copy of it promptly in any event before the period of 7 weeks if it's reconsidering the school's decision, 12 weeks in all other cases of it being brought to its attention or otherwise appearing to them that the child may have ALN. And again, what they must notify the parent of is detailed there. And again, information importantly about the right to appeal to the tribunal. And local authorities will maintain an IDP for children and young people who are not pupils at a maintained school or maintained further education institution. They will maintain IDPs for looked after children under compulsory school age who aren't at a maintained setting, young people in specialist post-16 education, and children at independent schools as well. So in those circumstances, it's really the school will only be involved if it's maintained mainstream school, and also that applies to nurseries as well. There are the same duties on the local authority to secure the ALP and the IDP, again, unless it's provided by an NHS body, in which case the NHS body must provide it, or if it's transferred that responsibility to the school. And again, the equivalent duty to take all reasonable steps to secure ALP in Welsh if that's in the IDP. There's also a duty on schools to take all reasonable steps to help the local authority to secure the ALP and the IDP. So, for example, training and developing their staff, ensuring there's appropriate equipment, involving the child and parent in the process and decisions, and ensuring that teaching staff are aware of the child's ALN and ALP as well. Okay, so coming on to the next slide, if the child is to be a registered pupil at a maintained school, there are some circumstances where a local authority may instead direct the school about an IDP. So again, it's this circular thing that we've spoken about. I mean, where a local authority decides that a child has ALN, it may then direct the school to prepare and maintain an IDP. Where it's decided a child has ALN, it's then gone on to prepare an IDP. It may, if it considers it appropriate, then direct the school to maintain the IDP. Where the local authorities revised an IDP following a tribunal order, the local authority may then direct the school to maintain the IDP, or where the local authority already maintains an IDP, it could then direct the school to maintain it. But this is important. It shouldn't direct the school to prepare an IDP unless it be reasonable for the school to secure the ALP. The school could not adequately determine the extent and nature of the ALN, and the school could adequately determine the ALP, as we discussed before. And it must not direct school, as we said, if the child is dual registered or the local authority is required to specify a place at a particular school or other institution or board and lodging in the IDP. So that, I think what that's getting at there is, you know, it can't direct a current school that's saying we can't meet needs to maintain the IDP if actually a different school is going to be named in the IDP, because that, you know, that just doesn't make sense. So in that case, it would be the local authority. Okay. So where a local authority directs and maintains school to prepare and maintain an IDP, the code says that a local authority should do so promptly and sufficiently early within the period within which it otherwise would have been required to prepare and give a copy of the IDP. This is so that the school then has that adequate time to prepare it and it doesn't sort of lead to delay. And the periods are the same for the school to prepare the IDP and give a copy to the child or parent. So it's a difficult one. I think, as I say, the code is trying not to add in that delay. I hope we won't see that delay, but I do think there will be circumstances where if the local authority is reconsidering and then it's passing it back to a school, it does have the potential to become quite convoluted. So these are other sort of relevant provisions. So ceasing to maintain, the governing body of the school, the maintained school or local authority can decide to cease to maintain the IDP if it decides the child or young person no longer has ALN. So again, this is shifting a responsibility to the school to make that decision, which they won't have been used to. But child and parents and young people, importantly, can request that the local authority reconsiders that decision, and it has 4 weeks to do so, and then ultimately has a right to appeal to the tribunal if they're unhappy with the local authority's decision. IDPs must be reviewed at least annually, and that's at least. It doesn't mean annually. It means if there's a reason to do it sooner, it should be sooner. And the code says that it should be monitored on an ongoing basis by the body that's responsible for maintaining it, and should conduct reviews as often as required. If there's been a significant change in circumstances or new information has come to light, then an earlier review will often be appropriate. If a request to review an IDP is made by the child or parent or young person to the maintained school, further education institution or local authority, it must conduct a review unless it considers a review to be unnecessary. So you can make that request. And as I say, you will have that right to appeal to the tribunal if you're unhappy with the local authority's ultimate decision. And these are, I'm just highlighting these for you because, as I say, there's so many different sections of the code and different sort of individuals that it applies to. Duties in relation to children of compulsory school age who are not registered at a maintained school, that's chapter 13 of the code. It's the duty on the local authority to decide if the child has ALN and to prepare and maintain the IDP in those circumstances. Duties in relation to young people, so people over compulsory school age at maintained schools. It's similar, but the young person will be involved rather than the parent, and they need to seek that young person's consent to the decision being made. Duties in relation to young people at further education institutions, that's chapter 17, and duties in relation to children and young people receiving education otherwise than at school, so provision at home. A local authority may only arrange for the additional learning provision described in an IDP, or any part of that provision, and that's important, to be made otherwise than in a school, so you know, at home or elsewhere, if it's satisfied that it would be inappropriate for the ALP to be made in a school. And there's some helpful points on that in chapter 18 of the code. Independent schools, as we said, are not required by the Act to decide whether a child has ALN or to maintain an IDP. They are, however, subject to the standards regime for independent schools about the quality of education, provision of information. And a local authority deciding whether a child attending an independent school has ALN or preparing an IDP for that child should work with the independent school to try and identify the ALN and ALP And when maintaining an IDP for such a child, to secure the ALP, the local authority should work with the school to satisfy itself that it's being delivered. Okay. Chapter 14 deals with duties in relation to looked after children. Chapter 15 deals with duties in relation to young people at maintained schools. Okay, so the contents on IDP, this is why I was saying that it is very different. It's got sections, it's got sort of subsections, it's got sort of 2A point something, and it's not the easiest thing to read, if I'm honest. I haven't yet seen one in practice. I'm just going off the annex to the ALN code, and it's Annex A if you want to have a look at it. But as you will see, it's got sort of these sections and subsections. So 1A is biographical information about the child or young person. 1B is who's responsible for the IDP and the review date. 1C is the about me section, so that's sort of the all about me section. 2A is importantly the description of the additional learning needs, so that's an appealable section, and that's previously our part 2. 2B is the description and delivery of ALP. So that includes outcomes, the ALP that's to be provided, and it's not the whole of this section that's appealable, it's certain bits of it. And again, this is why I think it becomes complicated. So the ALP to be provided, the actual provision, that's appealable. Should it be provided in Welsh? Again, that part is appealable. And then there's some other sort of parts in that in relation to which organisation or service will provide it, the rationale, etc. 2C is the description and delivery of any ALP to be secured by an NHS body. Most parts of this section will be appealable. 2D is the school or institution named, and again that is appealable. So that's your part 4 from your statement. And then there's these other parts in relation to sort of transition planning, travel arrangements. In relation to travel, the position will still be as it is currently under the Learner Travel Wales measure. So it won't, those preparing an IDP can, where relevant, record arrangements for travel to school, but in many cases there just won't be an additional benefit of doing that, because the law is as it has been, and this section's not appealable. Okay, coming on to the next slide. Then these were just a couple of points that I picked out from the code. So section 2A, so that's the additional learning needs. It says the description of the child or young person's ALN should be as clear and comprehensive as possible and include the impact of the need on the child or young person's learning in as much detail as possible. So it says should, it doesn't say must, and that's I mean, there's case law around this, so I think in terms of it's likely that they will still be required to specify and quantify, but and I hope that this doesn't again dilute any rights, but these are sort of helpful parts of the code to point to if you are you know, seeking an appeal, because it does set out really what they should be doing. Section 2B.2, this section should, where relevant, include details of how regularly the ALP is to be provided. For example, daily, weekly, at weekends, school days only, term time only, or once each term. So again, that's getting at like specification, quantification of provision, and that's important, and it should be detailed, specific and quantifiable. Simply stating that support will be provided will not meet the need for clarity. Describing the tasks any staff will undertake or facilitate, what they'll be responsible for, and if applicable, what qualifications or training they'll require is important. So I think those are some helpful extracts that you may want to rely on in future. School choice. So there is still a presumption in favour of mainstream schools. Local authorities must name a mainstream maintained school unless one of the following apply. It's incompatible with the provision of efficient education for other children, and no reasonable steps could be taken to remove that incompatibility, importantly, because if they can, they should be. Education other than in a mainstream maintained school is appropriate in the child's best interest and compatible with the provision of efficient education for other children, or, and importantly, where the child's parent wishes for the school for the child to be educated otherwise than in a mainstream maintained school. So you have that right to say if you want your child to be educated otherwise than in a mainstream maintained school. However, this does displace the duty to secure mainstream maintained education, but there is no absolute duty to secure that the child is educated in the way that parents want. I'll put, however, and I'll come on to this. So the local authority's duty to secure that the child is educated in a mainstream maintained school does not apply, so it's displaced, if the parent wishes their child to be educated otherwise than in a mainstream maintained school. However, where this is the case, the local authority is not necessarily required to secure that the child's educated otherwise than in a mainstream maintained school, but the local authority must have regard to those wishes and will need to consider the circumstances of the case. So it's important, but it's not necessarily determinative. A decision not to educate a child in a mainstream setting ought not to be taken lightly in any circumstances, especially if a parent would prefer mainstream schooling. The local authority must have regard to the views, wishes and feelings of the child and the child's parents, and other relevant factors, including the ability of the mainstream maintained school or any potential alternative setting to offer appropriate ALP. So these factors, together with the views of educational psychologists and other relevant specialists, should be taken into account, and it's important that all decisions are taken on the basis of the individual circumstances. So this is where, if we were, assisting with a tribunal appeal, we would be, pointing to all of those additional circumstances that mean that school, your parental preference is appropriate and meets the child's needs. School choice for independent schools. So for a local authority to describe and secure provision at an independent school in Wales, it must be on the register of independent schools in Wales, and the local authority must be satisfied that that school can make the ALP and the IDP. Where a child or parent would prefer a placement at an independent school, but the child's reasonable needs for ALP could be met in a maintained education setting or a further education institution, the local authority is not then required to fund the learner's place at that independent school, but it should explain the situation of the parent and child, how their needs could be met without recourse to an independent placement. And of course, that is something that you can appeal in a tribunal. And there are there's some guidance in the code when a local authority is considering whether they should place the child or young person at an independent school. They'll need to consider whether the evidence demonstrates that the ALP required is only available in that school.
Sorry to interrupt, Beth. I think the slides are still on contents of the IDP.
Oh, sorry.
Is that right?
No, keep going.
Backwards, sorry.
Sorry, it's my fault. I should have.
It's still on IDP for everybody else, so it might need a refresh.
Oh, is it? It's frozen.
Right, okay, what I'll do is I'll just stop sharing for a second and then I'll reshare.
Thank you for that. Do say if it's
sorry,
lagging.
One moment. So it should be on school choice now for everyone. Is that all right?
It's not come up screen just yet.
It wouldn't be Zoom without one technical glitch, would it?
Yeah.
Still black.
It is.
One sec. Can you see my screen yet?
It just says that you've started screen sharing.
Right, okay. Then what can you guys see?
That's all we can see, just a black screen.
Right.
It might be worth, Nicole, you just signing out and coming back in.
Okay.
And then we can start it again. Is that okay?
Yeah, of course. 1 sec.
It's the perils of virtual presentations. Apologies, everybody. So we'll just wait for Nicole to come back in, and then we'll make a co-host again. If anybody would like to, get themselves a quick drink, or if they need a break, this might be a good time. Although we're coming to the end of the session, but right, okay, I can see Nicole. Let's have a look.
Can you hear me now?
Yep.
Okay, dogs. I'll just try and share my screen again quickly.
So we might have missed a few slides because it was stuck on the IDP slide.
Okay, which one would you like, Bethany?
It would be worth to go back to what we potentially have missed, just so we've got it on the screen.
We were on contents of the IDP, weren't we? So it would be school choice, the next one.
Okay, doc.
There we go. Perfect. Yes, so this is the point in relation to the mainstream maintained school that we spoke about, and when a local authority doesn't need to name a mainstream maintained school, and that includes, so basically that presumption in favour of mainstream is displaced if the parent or child wishes for the child to be educated other than in mainstream, or it can be, but then there's no absolute duty to secure the provision that the parents want. But they must have regard to parental wishes, and it does highlight the importance of mainstream, and that a decision not to educate in mainstream ought not to be taken lightly in any circumstances. So okay, go on to the next slide. So these were the quotes that I read out from the ALN code about mainstream settings. I won't go over it again, but it's just there for you to peruse. And in relation to, just moving on to the next slide, in relation to independent schools, as I said, so for the local authority to describe and secure provision in an IDP at an independent school, it must be on the register of independent schools in Wales, and the LLA must be satisfied that it can make the additional learning provision in the IDP. So is that where we got up to? Was I going through the considerations for a local authority when considering whether to place the child or young person at an independent school? I'll just if you just pause on that slide for a minute, I'll just talk this through. It's not on the slide, but where it's considering whether they should place the child or young person at an independent school, then they need to consider whether the evidence demonstrates that the ALP is only available in that school, or the child or young person has medical or social care needs that can't be met by local providers in a maintained school or further education institution, and that would prevent them from accessing educational training suitable to meet their needs. If provision to meet the child or young person's needs could also be secured at another independent school, where the placement at that particular independent setting would be compatible with the provision of efficient instruction and training, and the avoidance of unreasonable public expenditure. So these are the sorts of arguments that we expect local authorities to be making around, if parental preference is for an independent school. Okay, so appeals against decisions then. So we touched upon this earlier, but you can appeal against a variety of decisions in the Educational Tribunal for Wales. And there are, as I said earlier, 2 tribunals running in parallel until the old system's phased out. And there are 2 different websites. If you Google Education Tribunal for Wales, it'll come up. I think I put the websites on the next slide, actually. And So it depends where you are. If you're still in the statement to process or the SEN assessment process, then you would still go to SEN 2. If you're in the new system, the ALN system, then it would be going to the Education Tribunal for Wales, and there are guides on the website. There are some helpful, obviously there's the application forms, and there's a lot of helpful information on there for parents if you're looking to appeal. So that's the best place to look for that. And the decisions that can be appealed, as I say, there's a lot of them, because there's various different sort of stages of the decision. But importantly, you can't challenge the school in the tribunal. So you have to go through that, asking the local authority to reconsider first, and then appealing that decision. Further education institutions, interestingly, can be challenged in the tribunal. So that will be new to them. And it'll be interesting to see how that plays out as well. But if a local authority or further education institution makes a decision as to whether a child or young person has ALN, that decision is appealable. A decision as to whether it's necessary to prepare or maintain an IDP, that's a decision which is appealable. The local authority refuses to decide a matter because it says there's been no material change or no new information that's come to light. You can appeal that decision. The local authority decides not to take over an IDP from a school, again, appealable. A decision to cease to maintain the IDP by the local authority or further education institution, that's appealable. And then the contents of these sections which I've listed, and it is effectively largely as before, you know, the special educational needs, additional learning needs, the additional learning provision, the name of the placement. There's also that in relation to any provision in Welsh. As I say, so in terms of the timeframes, children, young persons or parents can bring an appeal. It's 8 weeks is the standard timeframe to from the date of the decision to bring an appeal. But if you decide to use the local authority's independent disagreement resolution services, which are available, and there's more information on that on the tribunal website, then you can extend the time to apply to the tribunal for a further 8 weeks. So that's potentially 16-week timeframe in total. Okay, and just to note as well, children can bring their own appeals to tribunal if they have sufficient understanding, which is interesting. And children who lack capacity can still bring an appeal in their own name, but they'd have a case friend to represent them and to take decisions on their behalf if they have a parent who's willing or able to bring the case to the tribunal. Sorry, if they don't have a parent who's willing or able to bring the case to tribunal. So that's interesting, and then the code deals with that as well. And these are just some helpful websites, some key websites. So as I said, there's the SEN 2 website for statement appeals. There's the Education Tribunal Wales website for IDP appeals. As I said, contains the appeal forms and various guides that you may find helpful. The Welsh Government announcements page. This is where you'll get any announcements on updates to implementation in the Act. And you can actually filter it by education, and so that's often a good place to look to see what the most up-to-date position is. I've just put Contact's website there as well for you, as that contains a lot of helpful information. And this was everything I had. I've put there our new inquiries line at Irwin Mitchell in case anybody does require assistance, and also you can inquire online through our online inquiry form, and Contact have a free helpline as well, that I've put the details there, and I've also put some other helpful links that you may want to follow. I'm sure Kate will explain in a bit more detail how those help, and what, you know, what they've got available for you. But that was everything. We have run over time. There was a bit of a technical glitch. I don't mind taking a couple of questions if that's okay, Kate, or I can follow up by email, whatever works best, really.
Yeah. If we can keep that screen up, please, Nicole, because it's got all the contact details. Thank you so much, Bethany. There are quite a few questions in the chat. already. So it'd be good if we could perhaps go over some of those, or if not, if we can answer them after the session. And we've also put our survey, our contact survey link in the chat for feedback on today's session, if people wouldn't mind completing that. After the session, Bethany, if you're able to respond to those questions, I can then share the question and answers with everybody who's attended, and send that by email. I realise we've had some hiccups with the link going to another webinar, so I do apologise profusely to everybody for that. But we are recording the session, and we will share that with everybody. And I will discuss further with Beth what else we can send on to you. So Beth, are you able to look at the chat, or do you want?
Yeah, I've had a look. There are quite a few questions, so I think the best way to do it is if I go through them as you said, and then I can do an email for you to send out to everyone. Would that be okay?
Yeah, and I will send the as I said to everybody, I will send the questions and responses to everybody. I'm going to stop the recording now, but not actually stop the session. Okay, but thank you everybody.